Gracefully Graying, we will be discussing options for the elderly who have been affected by severe illness or assisted living expenses with my guest, Steven Cohen of Lipson Neilson. I am your host, Attorney Henry Gornbein, and without further ado, I would like to welcome Steve Cohen to Gracefully Graying. Steve, first of all, tell us a little bit about your area of expertise.
Thank you, Henry, and thank you for having me.
Pleasure.
I've been practicing law for 30 years, 24 of those years exclusively in the area of bankruptcy law. And in the bankruptcy field, I represent both debtors and creditors alike. This includes Chapter 7, 11, and 13, helping debtors channel their way through the process from beginning to end. On behalf of creditor representation, depending upon the nature of the creditor's claim, options may include seeking to prevent a debt from being discharged, seeking to have a debtor's bankruptcy case dismissed for bad faith, seeking relief from the automatic stay for the return of their collateral, or simply filing a proof of claim. I have also represented Chapter 7 trustees during the course of a bankruptcy. And in addition, I have been a guest speaker on the topic of bankruptcy at various events. Most recently, I talked at the Michigan Association of CPAs, referred to as the MICPAs. The topic was cancellation of debt, wiping the slate clean. And before that, I was a speaker at the Stephen Rhodes Detroit Consumer Bankruptcy Conference. The topic was everything you should know about student loans in bankruptcy. Also, I've been retained to be a bankruptcy expert in pending litigation, so suffice to say, my expertise is bankruptcy law.
Let's start by discussing some options for the elderly who are in debt. First of all, Steve, tell us what an out-of-court workout is and how it would be handled.
Sure. Out-of-court workout, simply stated, it's an out-of-court workout is a settlement or settling with creditors without filing a bankruptcy. Like anything else, there's advantages and disadvantages. The advantage of an out-of-court workout is we treat creditors differently, meaning that we don't have to settle with everyone. Perhaps seek to settle with those creditors that are causing the most grief, and other creditors that you may have you just don't want to settle with. You want to pay them over the long term. The biggest disadvantage of an out-of-court workout is forgiveness of debt. It's a taxable consequence to which you will receive a 1099-C. Let me give you an example. Let's assume that you owe Discover $15,000 and we're able to settle it for $10,000. Well, they'll probably issue a 1099 for that $5,000, which you are expected to pick up on your tax return. If you don't, the IRS will also get a copy of that 1099. So they will send you something at the end of the year and it will not be a Christmas card. So that is a disadvantage of an out-of-court workout. And it can get costly because there's more time involved with negotiating with various creditors versus simply filing a bankruptcy.
Let's talk about options in bankruptcy. First of all, Steve, tell us about Chapter 7 and how that works.
Sure. While there are a variety of bankruptcy chapters available, there are two chapters that are mostly used. Chapter 7 is referred to as a liquidating bankruptcy. What that means is that you can exempt or protect certain assets under the bankruptcy code, and what you cannot protect, a trustee who's assigned to your case has the responsibility or obligation to sell the assets that you cannot protect, turn it into cash, and disperse it to your creditors. A process takes typically about 100 days from start to finish. Now, that might sound scary when I refer to it as liquidating bankruptcy, the trustee is going to sell your assets, but most often, most assets are protected in Chapter 7 bankruptcy, meaning that most cases are no asset cases, which means most of your stuff would be protected. You don't have to worry about a trustee. If there are issues to which there are assets that are not fully exempt, then we talk about it beforehand and we try to do what we can to keep those assets or understand what's going to happen through the bankruptcy process.
Steve, let's talk about Chapter 13 now for our viewers.
Sure. Chapter 13 is referred to as the wage earners plan. It enables individuals with regular income to develop a plan to repay all or part of their debt. Unlike under this chapter, under a Chapter 13, debtors propose a repayment plan to make installments to creditors over 3 to 5 years. And let me explain again how a 7 works, just so we're clear.
Sure.
With the Chapter 7, it's a liquidating bankruptcy. Trustee, as I mentioned, is assigned to your case, has a responsibility to liquidate those assets that you are unable to exempt or protect, turn it into cash, and disperse the cash to your creditors. Yeah, with most Chapter 7 cases, we can usually protect most, if not all, of the assets. Most cases are filed as a Chapter 7, not a Chapter 13. That's why I want to go back to a Chapter 7. Um, and I already gave you an example. Let me give you another example. To the extent that
Sure.
an asset cannot be protected, we can either negotiate a deal with the trustee, such as we purchase the non-exempt equity from the estate. And let me give you an example. I love examples. They usually help me understand and help others understand too. So let's assume you own a car free and clear. Um, Fair market value is $7,000. However, if we apply the federal exemption for that vehicle, the federal exemption is $4,000, which means there's $3,000 that's not protected. Now, assuming that there's no other exemptions available, a trustee could seek to sell that vehicle, give the debtor their $4,000, and retain the $3,000 for the benefit of the creditors. But most often in that situation, we would avoid having the trustee sell the car
How do you
because we
do
would
that?
offer to negotiate with the trustee. So in other words, instead of having the trustee sell the car, we would try to convince, look, we'll give you $1,000 or 500 or something less. And most often the trustee doesn't want to take a debtor's assets. And as I think I mentioned with a Chapter 7, it takes about 100 days from start to finish.
So Steve, is it correct in saying that there's a lot of flexibility, that you do a lot of negotiating with the trustees to try and preserve assets when you're going through a Chapter 7?
I do. And most often we go through, the client knows what assets are going to be potentially exposed and what assets are not going to be exposed. There's no secret when the debtor files a bankruptcy. I don't want them to be surprised. I want them to go in eyes wide open. What I do is I spend my time educating my clients. So for the most part, they can actually teach a class in bankruptcy. Because I think the more they know, the more that they'll understand. One thing I wanted to mention before, with regards to a 7 or a 13, you asked me the difference. What you didn't ask me is why people file a 13 over a 7 or a 7 over a 13.
Yeah, that's an important question.
It is a very important question because oftentimes clients say to me, this is what I want to file. This is what I was told I should file, but it's not necessarily the right chapter. Why do people file a 7 over a 13 or a 13 over a 7? It's based typically on your income and your expenses. There are some exceptions, but typically we take a look at your monthly income and your monthly expenses. Let's assume the monthly income is $5,000 from all sources. Now we go through your monthly expenses. What's your rent or mortgage? Utilities, monthly food expense, clothes expense, health insurance, co-pays, prescription drugs, car payment, car insurance, all the necessities of life. Even if you tithe, that's an expense. After we go through your income and your expense analysis, if you have more than $100 left over at the end of the month, in theory, you should be in a Chapter 13 where you pay something back to your creditors. If you don't have at least $100 left over at the end of the month, then you should be in a Chapter 7 because you don't have any extra funds or excess funds available to pay your creditors. Now, there are some exceptions. If, for example, most of your debt is business debt, not consumer debt, then the income and expense doesn't really matter. You can have excess income and still file a Chapter 7. Also, I did want to mention the biggest advantages of filing a Chapter 13, which this is what I typically see when we file a Chapter 13. It enables you to catch up on your mortgage payment. So let's assume, hypothetically speaking, you lost your income for a period of time, lost your job, something happened, not able to work. So you got behind in your mortgage payment. We don't want a foreclosure. So prior to a foreclosure sale happening, we could file a Chapter 13 and actually come up with a plan of how we're going to cure the deficiency over a period. It could go as long as 3 to 5 years. Typically, we try to pay it within about 3 years. With a Chapter 7, there's no opportunity to fix the arrearage. Same thing with a car payment. If you're behind your car payment, you can also file a Chapter 13, and that will enable you to catch up with your car payments, unlike a Chapter 7 bankruptcy.
Steve, let's say someone really doesn't want to get involved with the legal system and decides to do nothing. What happens?
Well, sometimes it's a good time to travel the world. Go to another country and just travel the world. But the reality is this: sometimes I recommend to clients, even especially if they're retired, do nothing. If you've got assets that are completely protected, that a creditor cannot touch, then sometimes doing nothing is okay.
What would be examples of those assets that are completely protected?
Real estate owned by husband and wife, Real estate owned by husband and wife is exempt from all creditors but joint creditors. So let's assume that you and your wife own a house and the house is worth $700,000 and you have no mortgage on that house whatsoever and you have no joint debt. The only debt that you have, Henry, is a creditor against you, but your wife's not on the hook for that. Well, that creditor cannot attach the house at all, even if they get a judgment. The only way they can get access to that house is if, God forbid, and I am sorry for using you as the example, if you end up as a surviving spouse, then you would become the full owner of the house, and the house is no longer protected. But that's an example. Another example would be IRAs. Your IRA is protected from creditors. Social Security is protected from creditors. I have been contacted by seniors. Their sole source of income is Social Security. They've extended themselves in terms of credit card where they cannot pay their credit card debt in full, but their only income is Social Security. And sometimes I suggest you don't have to file a bankruptcy because a creditor can't get to you. If they get a judgment against you, they cannot garnish your Social Security. So it is protected. Now, there are some issues with doing nothing. First, most people don't want to get those phone calls, harassing letters from collection agencies or attorneys seeking money. And sometimes a bankruptcy will just stop that. And what do you do if a court officer? So if someone files a lawsuit against you, gets a judgment against you, gives an execution against property to a court officer, and a court officer comes knocking on your door, well, all your assets may be protected. What are you going to do when a court officer is knocking on your door, which usually happens on a Saturday late afternoon where the attorneys have all gone home for the rest of the day? Who do you call? What do you do? So those are sort of issues if you do nothing, but some people are able to do just simply nothing.
Steve, let's talk about taxes. How are taxes dischargeable in bankruptcy?
Okay. Well, there's a myth that taxes are not dischargeable in bankruptcy. Why? Because it's a debt owed to the government, and that can't possibly be discharged in a bankruptcy. Well, that is not true. Well, not all taxes are dischargeable. For example, a 941 tax is not dischargeable. 941 tax, as an employer, I have employees. I hold back some of their taxes for the government. I'm holding those taxes in trust. Those are 941 taxes. If I filed a bankruptcy, that tax would not be discharged in a bankruptcy. But individual income taxes can be dischargeable in a bankruptcy. When I say individual income taxes, I'm referring to from January 1st to December 31st, you're paying money to, or you should be paying money to the IRS and your state tax income. And come April 15th, you square up with the IRS or your state to figure out who owes what, any money. Those are individual income taxes, and those taxes can be discharged in a bankruptcy.
What are 5 rules that must be met with regard to dischargeability of taxes in bankruptcy?
Okay, if you are seeking to discharge those taxes in bankruptcy, a couple things to keep in mind. One, the taxpayer cannot be guilty of tax evasion. Tax evasion is not listing your income. I mentioned before about a 1099 and not including that on your tax return. Well, that's considered tax evasion if you're not listing your income on your tax return. Number 2, the tax return cannot be fraudulent. An example would be you can't try to claim your dog as a dependent and then file for bankruptcy after the IRS challenges your tax return to discharge those taxes. Number 3, the tax assessment has to be at least 240 days prior to the bankruptcy filing, which is basically 8 months. A tax assessment is when the IRS declares you owe a specific dollar amount. You need to wait at least 240 days before you file bankruptcy. Number 4, and this is really the crux of the dischargeability of a tax. The due date of the filing of the tax return in question has to be at least 3 years ago. And the due date includes any extensions. And let me give you an example. Let's say that in 2020, you filed your 2020 taxes, April of 2021, and there's a tax debt, and you didn't pay that tax debt because you couldn't afford it. You would need to wait until April of 2024 to discharge your 2020 taxes. And 5th, the tax return was filed at least 2 years ago. There's a couple important notes to take from this. First, tax debts that arise from unfiled tax returns are not dischargeable. So if you don't file a tax return, the IRS will go out of their way and file a substitute return for you. That is not considered a tax return filed by you. So you have to file the returns. Number two, always file your tax returns, even if you don't have the money to pay that tax debt. And it's so important. There are so many clients I have met with where they don't file the returns because they didn't have the money. And let me give you a great example right now. I'm representing somebody in a Chapter 13 bankruptcy, and they did not file certain tax returns from 2015 and 2016. As a result, those taxes will not be discharged in their bankruptcy. However, in their case, we filed a Chapter 13, and those 2015 and 2016 taxes will be paid during the course of their Chapter 13. So at the end of their bankruptcy, they'll no longer have any prior tax obligation. However, if they would have filed those returns, they would have been discharged by the filing, and we would have to make those payments to the IRS at this time in their bankruptcy.
Steve, what if you are a creditor and someone who owes you money files for bankruptcy?
Jumping fence now. Okay. So if you are a creditor, someone files a bankruptcy, all is not lost. Doesn't mean that you just rip up the debt and you throw it away. You do have options depending upon the claim at hand. For example, was the debtor a builder doing work on your home? Well, there's something called the Builder's Trust Fund Act. Builder's Trust Fund Act is when a builder, when you receives a deposit from you, they're actually holding it in trust for labor, suppliers, and material men. And if they try filing a bankruptcy and they haven't used those funds for labor, suppliers, material men on that job, that debt, to the extent they didn't use that deposit, would be non-dischargeable in a bankruptcy. Another example was the debt incurred within 6 months of the debtor filing bankruptcy. Did you have or do you have a security interest in one of the debtor's assets? I represent a few auto lenders. So if a debtor files a bankruptcy and they're leasing or purchasing a car from one of my clients, well, they don't just get away with keeping the car and not making payments. I actually take steps to either make sure they reaffirm the obligation, they're going to pay for that car, or they're going to give that car back. Are you familiar with the transactions of the debtor? We'll review their bankruptcy schedules. Are there assets not listed, transactions not disclosed? Perhaps there are grounds to seek the dismissal of the debtor's bankruptcy. This is often common in a divorce situation. One spouse or ex-spouse files a bankruptcy and they owe you money. Well, that debt really is non-dischargeable, but you will know typically more of their financial situation. And if they've lied on their bankruptcy schedules, it could be grounds to seek the dismissal of their bankruptcy.
Steve, are there different options if it is a Chapter 7 versus a 13 if someone owes you money?
Yeah, we treat it differently. With a Chapter 7, do we have a claim that could be non-dischargeable? For example, was there ever an intent to pay you back? Someone borrows money from you 3 months prior to filing a bankruptcy, and then they try filing a bankruptcy to prevent, and they want to discharge that obligation. Well, most people, 3 months prior to filing a bankruptcy, they sort of had a thought that they're going to file a bankruptcy. It's not something you wake up one day and do you want to go to the movies? Do you want to go to the zoo? Let's file bankruptcy. So if there wasn't not an intent to file to pay that debt back, grounds to prevent the debt from being discharged in a Chapter 7. Was there a violation, as I mentioned before, of the Builder's Trust Fund Act? Was the loan made on the eve of the bankruptcy filing? I've seen situations, I represented the credit card company where a debtor, before filing a bankruptcy, they went on a shopping spree and they purchased about $600 worth of nonsensical stuff. That debt was non-dischargeable in a bankruptcy. Was their monthly living expenses reasonable in a Chapter 7? And I've seen this before firsthand. I've seen a husband and wife file a Chapter 7 bankruptcy. They were both doctors, but they had a lot of debt because of certain obligations that they guaranteed, and they couldn't pay the obligations. They were being sued. So they filed a Chapter 7 with $50,000 of monthly income, but they also showed $50,000 of monthly living expenses. And it was, suffice it to say, it was considered bad faith in that Chapter 7, and that Chapter 7 bankruptcy got dismissed.
Sounds a little fraudulent. Steve, tell us about some bankruptcy myths.
Well, I want to go back. You asked me about 7s. What about in 13s and creditors?
Okay, yes, let's cover that.
So if we represent a creditor in a 13, couple things to do. One, first and foremost, make sure that we file or you file a proof of claim. If you do not file a proof of claim, you will not share in any distribution. In addition, in a Chapter 13, we would review the bankruptcy the bankruptcy schedules and the Chapter 13 plan. Is the plan feasible? Are the debtor's expenses reasonable? Example, a monthly food expense of $1,000 for a family of two. Is that reasonable? Monthly clothes expense of $500 for a family of two. Monthly car payment of $800 for one car, contributing $500 per month to their 401k. Are these reasonable expenses? How about monthly rent of $2,500? These expenses are not reasonable. And the idea is if a debtor is trying to get a fresh start, they need to tighten the belt, reduce these expenses to have some meaningful distribution to the creditors. So that's what we do in a Chapter 13 bankruptcy representing a creditor.
Okay, now let's jump to bankruptcy myths. And I know there's several you'd like to cover. I think we already discussed what happens to your house, but let's go from there.
Well, here's a couple of them. And I love this because oftentimes I'm taking language from somebody else. Don't confuse, I'm going to say this wrong, but don't confuse my bankruptcy law and experience from your research on Google or from your friends. So with regards to a house, people do often say, if I file bankruptcy, I will lose my house. Well, that's not necessarily true. It's possible. And I'll give you an example where it's possible, but if there's a thought that you're going to lose your house, we probably wouldn't file the bankruptcy or come up with another plan, like maybe a Chapter 13 where you would keep your house. Another myth, let's see. If you file for bankruptcy, you will never again be able to buy a house or a car. Well, that's not true. I actually, in a bankruptcy, recently did a refinancing for a client who was in a Chapter 13 bankruptcy, and we actually, in a Chapter 13, their interest rate was 8% on a 30-year mortgage. And we're able to get a 3% interest rate, 30-year mortgage, nothing down, in a Chapter 13 bankruptcy. In addition, you will absolutely still be able to purchase a house and a car. You may not be able to get a mortgage right away following a Chapter 7 discharge, but you will be able to get financing. And even in a bankruptcy, you can get funding to purchase or lease a car. And let me give you a quick example on that. Let's assume that you have a 3-year car lease, but you have a 5-year Chapter 13 plan. What happens if in the middle of that Chapter 13, you've got to surrender your lease? What do you do? Well, yes, you can get another lease. As long as you're making your payments, lenders will absolutely still give you credit and you'll be able to get another car while you're in a bankruptcy. Another myth, that bankruptcy will ruin your credit record. Well, that's false. Your inability to pay your debts on time ruins your credit. After you file bankruptcy, many of your debts will be discharged and you are given a fresh start. Keep on top of any new debt after bankruptcy and your credit record will actually improve. Another myth that I hear is that your spouse is automatically liable for your debt. Well, that's not true. You are not liable for your spouse's debt. My recommendation is try to avoid a joint credit card. If it's a joint credit card, obviously that's joint debt.
Sure.
The only joint asset you really should have is the house. Everything else should be in your personal name, even a car. A car should not be held jointly. Why? God forbid you get into a car accident and the car is owned jointly. Whoever was injured, if they want to pursue legal action, will go after joint assets. If the house is joint, which it should be, they can go after the house. But if the car's in one name, they can't go after the house.
Steve, must married couples file together?
No, they don't. There are actually 2 separate bankruptcies administered as one case. So if a married couple, and I just actually had this, married couple, during the course of their bankruptcy, they're getting divorced. So what do we do about this joint bankruptcy? We actually sever the bankruptcy and make it into 2 separate bankruptcies, but they don't have to file together at all.
Is there a minimum amount of debt required for someone to file for bankruptcy?
No, but if the debt is, I have no magical number, but if the debt was somewhere around $10,000, I probably would try to see if we could do a workout or avoid a bankruptcy. I have represented people in bankruptcies with less debt for various reasons, but if there's a way to avoid a bankruptcy, I do that. I'm not a mill. I don't try just throwing people into a bankruptcy. If there's a way to avoid the problem, I do.
So bankruptcy should be a last resort rather than a first resort.
It is correct.
Steve, will you lose everything if you file for bankruptcy?
Oh God, no. You are entitled, and I may have mentioned this before, but you're entitled to exempt or protect certain assets under the bankruptcy code. The idea is that you get a fresh start. Doesn't mean you walk out of bankruptcy court with a barrel around you. You get to retain what's allowed under the bankruptcy code, and the bankruptcy code is somewhat generous. So no, you don't lose everything at all, not at all.
Before we sign off, are some other issues that we haven't covered? And can you provide some takeaways for our viewers before we end our discussion, Steve?
Well, some takeaways. Bankruptcy as a financial strategy is the best way I can put it. It is not and should not be construed as a personal judgment against you. Sometimes bad things happen to good people. Following a bankruptcy filing, you can rebuild your credit. If you do need to file bankruptcy, try to find an attorney who specializes in that field. I've seen retainer agreements from clients who have gone to other attorneys, and they have a litany of different areas they practice in, and then they write in bankruptcy. Well, they obviously don't practice bankruptcy law. On the creditor side, if you are owed money and that person or company that owes you files bankruptcy, all is not lost. You have options. Don't run from it. Don't just write it off. Explore those options with an attorney.
I think we live in an area of specialization in medicine and law. And an important point you're making is the fact that don't go to a generalist. You need someone who is an expert in all issues regarding bankruptcy and creditors and debtors' rights. So I think that's an important point for our viewers to take away from this. Are there any other points before we sign off, Steve?
Probably after we sign off, I'm going to think about 30 of them for the rest of the day. But right now, I think we've covered sort of a general information on 7s and 13s on debtor side and creditor sides. It's tough. With money, it's tough. Money's like gas. The more you make, the more you spend. And it's very difficult. It's eye-opening, I think, when I meet with clients and we work on a budget. That's first and foremost. When I meet with someone, we start off with, what is your monthly income? What is your monthly expenses? And how do we make changes to make this work going forward? Because what I hate to see is just rearranging the chairs in the Titanic, where their income is $5,000, their expenses are $6,000. I could put them through a bankruptcy, but that's not going to fix the problem. The hard part, it's the hard decisions to make if fixing the problem. How do we reduce the expenses to live within your means? And that's what I get most pleasure out of this practice, is helping somebody change their life so they don't have to go through this again. They don't have to worry about creditors, and they can get rid of their debt and put it in their rearview mirror.
I think it's sad, but too many people don't know how to live within their means, hence the need for your expertise. Steve, I want to thank you so much for being our guest on Gracefully Graying. We're out of time. And I want to thank you, our viewers, for watching this important topic of bankruptcy, especially as it impacts upon those of us who are gracefully graying. Thank you again.